Test, Palais Wilson, ground floor pour le webcast. 1, 2, 3, 4, 1, 2, 3, 4, 5. Test, Palais Wilson. Canal anglais, le canal 2.
Good morning, colleagues. I'd like to welcome you to meeting number 4257 of the Human Rights Committee. It is a public meeting and on webcast. It is devoted to the presentation of progress report of Special Rapporteur on concluding observations, Madam Yvonne Donders. I'd like to invite Madam Donders to present the assessment of the implementation of the recommendations made by Human Rights Committee to Germany and Armenia. Madam Donders, you have the floor.
Thank you very much, Chair, and good morning to everyone here in the room and those who are following us online on the webcast. Since our follow-up procedure is not very well known, allow me to briefly explain it. Since a number of years, the Human Rights Committee follows the 8-year predictable review cycle. This means that we monitor states parties' implementation and adopt our concluding observations every 8 years. Since this is a long time, we find it important to continue our monitoring and dialogue during that period. And therefore, we select 3 issues from our concluding observations on which states parties should inform the committee after 3 years. Other stakeholders are also invited to submit information, and on the basis of that, we assess the progress made. The criteria used for the assessment of the implementation of the follow-up recommendations can be found in document CCPR/C/161, paragraph 21. The report I present today assesses the implementation of the recommendations by Germany and Armenia. We would like to thank both states parties for submitting their follow-up reports. We also much appreciate the information from the human rights defender of Armenia. Unfortunately, no information was received from stakeholders from Germany. Let me thank all committee members who have reviewed the report prior to this presentation. My special thanks goes to Mr. Helfer for having provided valuable comments in writing, which have been duly considered in the current report. Any further comments by committee members are of course welcome during this public session. The overall recommended action for both assessments is to send a letter to each of the state parties informing them of the discontinuation of the follow-up procedure and that further information requested by the committee in this report should be addressed in the next periodic reports, which are due in 2028. I will now begin with the proposed assessment for Armenia. The 3 recommendations selected for follow-up were paragraph 16 on violence against women, paragraph 40 on the right of peaceful assembly and excessive use of force, and paragraph 42 on participation in public affairs. Under paragraph 16, the state party was recommended to redouble its efforts to prevent and combat all forms of violence against women, including domestic and sexual violence. The recommended actions for the state party were to A. Revise the law on domestic violence to ensure a victim-centered approach that guarantees access to immediate means of redress and protection. B. Establish an effective mechanism to encourage the reporting of cases of violence against women and intensify efforts to address the social stigmatization of victims. C. Ensure that all cases of violence against women are promptly and thoroughly investigated and that victims have access to effective remedies and means of protection, including sufficient and safe shelters and medical, psychosocial, and legal support throughout the country. And D. Consider to ratify the Council of Europe Convention on Preventing and Combating Violence Against Women and Domestic Violence. On paragraph A, the state party informed the committee of the changed title of the 2017 law into Law on the Prevention of Family and Domestic Violence and the Protection of Persons Subjected to Family and Domestic Violence. It also highlighted changes to several provisions, aimed at increasing the effectiveness of the fight against domestic violence, raising public awareness, and improving social and psychosocial support provided to victims. Other changes in the law include bringing definitions into line with the criminal code. For example, the definition of domestic violence now covers violence regardless of the circumstances of cohabitation, and also a child who witnesses violence or suffers negative consequences is considered a victim. The law further establishes free and preferential medical care and services for victims of domestic violence, and revised the deadlines for the implementation of urgent intervention and protection-oriented decisions. Furthermore, a centralized system was launched to register cases of domestic violence, and the data collected will serve as a basis for developing further strategic plans and activities. On paragraph B, the State Party informed the committee that work is underway to launch a mobile application called Safe You, which will allow victims of violence to promptly call the police and receive support. The State Party has further taken various measures to raise public awareness of domestic violence, including information corners in police units, as well as information on support centers and organizations providing services to victims. On paragraph C, the State Party referred to the Investigative Committee's annual reports on cases of domestic violence and provided numbers on criminal proceedings related to domestic violence that were investigated by the Investigative Committee. On paragraph D, the State Party stated that a strategic plan for the implementation of gender policy for 24-28 is currently being developed. This plan includes 6 priorities. 1, overcoming gender discrimination in all areas of management. 2, encouraging gender-sensitive approaches in labor activities and reducing the gender gap in the workforce. 3, overcoming gender discrimination in the field of education and science. 4, ensuring equal opportunities for women and men in the health sector. 5, ensuring prevention and protection from gender-based violence. And 6, developing gender-sensitive and gender-responsive approaches to climate change. Under the 5th priority, action is envisaged to ratify the Council of Europe Convention on Preventing and Combating Violence against Women and Domestic Violence. The human rights defender of Armenia notes that, despite legislative process, gaps remain in the prevention and elimination of domestic violence. Article 12 of the 2017 law prohibits the application of emergency intervention or protection orders against minors or incapacitated persons, which is problematic as regards the protection of certain victims. Misconceptions and stereotypes regarding women and domestic violence persist and are rooted throughout society, including discriminatory approaches among law enforcement and judicial authorities. The human rights defender recommended mandatory and ongoing training for relevant professionals on domestic and international standards. The human rights defender further notes that support services for victims, such as shelters and psychosocial and economic assistance, remain insufficient and unevenly distributed throughout the country. Furthermore, it notes that the draft National Strategic Plan for Preventing Domestic and Family Violence for 24-28 has been developed but not yet adopted. On the basis of the information received, the committee's evaluation for paragraph 16 is B. The committee welcomes the amendments to the law on family and domestic violence, including the provisions establishing free and preferential medical care for persons subjected to domestic violence. The committee is, however, concerned about reports about the discriminatory application of protection orders. It further regrets the lack of concrete information on the measures of redress provided to victims. It reiterates its recommendation and requests further information on the new amendments to the legislative framework, their practical application, and their impact on ensuring adequate enforcement and monitoring of protection orders. The committee also welcomes the work on the SafeU mobile application to facilitate immediate support to victims and the provision of information in police stations to increase public awareness on domestic violence. It regrets, however, reports indicating that misconceptions and stereotypes regarding women and domestic violence persist, as well as cases of professional misconduct. It reiterates its recommendation and requests further information on efforts made to increase awareness among the general public of gender stereotypes and domestic violence, tackling also the root causes and negative effects of domestic violence, and to address the social stigmatization of victims. It further requests information on the mobile application and its expected launch date, and on the evaluation of the impact of the mobile application on the reporting of cases of violence against women. The committee notes the data provided on the relevant criminal proceedings and requests additional information on the number of eventual convictions and the sanctions imposed, and on the medical, psychosocial, legal, and rehabilitative support services received by victims. It regrets reports indicating that support services for victims remain insufficient and reiterates its recommendation in this regard. It particularly requests additional information on the steps taken to increase the number of shelters in the state party and to ensure their adequate funding. The committee appreciates the development of a strategic plan for the implementation of gender policy in Armenia for 24-28. It, however, requests further information on the progress of the adoption and the implementation of the plan and on the specific action taken to ratify the Council of Europe Convention on Violence Against Women. Let me move to paragraph 40, the right of peaceful assembly and excessive use of force. This recommendation included that the state party should A. Strengthen its efforts to ensure that all law enforcement officers found responsible for excessive use of force during the events in March 2008, June 2015, July 2016, and April 2018, including those with command responsibility, are held accountable and appropriately sanctioned, and that all the victims of those acts receive adequate compensation and rehabilitation. B. Review the amendments to the law on freedom of assemblies to bring it into conformity with Article 21 of the Covenant. C. Refrain from undue interference with assembly participants and reduce police presence at peaceful demonstrations. And D. Ensure that impartial and thorough investigations are undertaken without delay by the Public Prosecutor's Office into all allegations of excessive use of force and arbitrary arrest and detention by state agents at protests. Finally, E. Ensure that domestic laws and regulations on the use of force are in full conformity with international standards, that all law enforcement officers systematically receive training on the use of force, especially in the context of demonstrations, and the employment of non-violent means and crowd control, and that the principles of necessity and proportionality are strictly adhered to in practice during the policing of demonstrations. On paragraph A, the state party informed the committee about several cases following the mentioned events. More details are in the report, but as a result of these cases, several police officers were found to have violated professional conduct, resulting in disciplinary measures, and other officers were found guilty of obstructing journalists, and they were fined, and some of them were dismissed from police service. Criminal proceedings were also launched into reports of bodily harm caused to journalists by police officers. Investigations also revealed that sonic grenade has been used unlawfully, but an amnesty law prevented persecution and disciplinary action was barred due to the expiration of the 6-month period under the disciplinary code of the armed forces. On paragraphs B and C, the state party mentioned that a new legislative package introduced the concept of the police guard, a specialized unit under the police distinct from armed forces. The draft law, developed with public and institutional input, is aligned with international standards. The law clearly regulates the use of force by police guard officers, detailing permissible methods, conditions, and requirements for proportionality. It also outlines officers' duties, rights, and training requirements. To ensure the package also includes draft amendments to the law on freedom of assembly, aimed in particular at reducing notification periods for gatherings, removing several restrictions on protest locations and durations, and limiting police intervention to cases where less restrictive measures are insufficient. On paragraph D, the state party informed the committee of several criminal proceedings that were initiated for allegations of the use of disproportionate force by law enforcement authorities during protests, with preliminary investigations still ongoing. The state party noted that the investigative committee consistently performs its legal duties by adequately responding to incidents of the use of disproportionate force during protests. On paragraph E, the state party outlined that during the period 21-24, approximately 349 officers received training on human rights and non-discrimination, on the procedure for the use of physical force, firearms, and special means by the police, on restriction of human rights and freedoms by police officers, on police powers in maintaining public order and ensuring public safety, and on the law on freedom of assembly. The human rights defender of Armenia informed the committee that it has identified systemic violations of the right to freedom of assembly, including mass administrative arrests, procedural irregularities, and disproportionate use of force by police. It also documented the use of sonic grenades during protests, resulting in injuries. Although criminal proceedings have been initiated, no police officers have been prosecuted. Disciplinary investigations were launched, but more than half of them have been suspended and others remain pending. Further concerns include obstruction of and violence against journalists and denial of access to legal assistance for detainees, including minors. The human rights defender further noted that despite legislative reforms, enforcement practices continue to undermine the right to freedom of assembly. It stressed the need for transparent oversight of police conduct, public disclosure of special measures used, and continuous training on the lawful use of force. The human rights defender further gave information on the status of criminal cases related to the events mentioned earlier, noting that some were consolidated in a single investigation, others were suspended, are still pending, or no further action has been taken. In 2021, following the exhaustion of local remedies, complaints were submitted on behalf of 3 journalists to international bodies, including the Human Rights Committee. On the basis of this information received, the committee's evaluation for paragraph 40 is B. The committee welcomes the adoption of the legislation on the police guard and amendments to the law on freedom of assembly, as well as the efforts taken to provide training to law enforcement officers on the use of force. The committee, however, regrets the reports of the continued disproportionate use of force by police and obstruction of and violence against journalists during protests. The committee reiterates its recommendations and requests further information on the new legislation, including its impact on the use of force by the police during demonstrations, and information on whether law enforcement officers receive systematic and compulsory training on the prohibition of excessive and unjustified use of force, and the promotion of the employment of non-violent means of crowd control. It further requests information on any investigations and the results thereof into allegations of arbitrary arrest and detention by state agents at protest during the reporting period. The committee further welcomes the information provided by the state party on the investigations and criminal proceedings regarding allegations of excessive use of force by state agents during protests. The committee is, however, concerned about the number of cases or proceedings that are still pending or that have concluded with no consequences or criminal sanctions. It also regrets the lack of information on the compensation and rehabilitation provided to victims. The committee reiterates its recommendations and requests information on A, the progress of the new criminal proceedings ordered by the prosecutor in January 24 to separate 10 cases involving torture and abuse of power relating to the events of March 2008. B, the proceedings related to injuries of more than 20 journalists as a result of the use of special measures by the police during the events of July 2015 and the reasons for their suspension. And C, the cases related to the earlier mentioned events that remain pending or for which no further action was taken. I move to paragraph 42, participation in public affairs. Under this paragraph, the state party should bring its electoral regulations and practices into full compliance with the covenant, including by A, ensuring that the mandatory disclosure of campaign financing information is fully respected to improve transparency and create equal conditions for the campaign. B, revising the limitations on the right to stand for presidential and legislative elections with a view to ensuring their compatibility with the covenant. And C, ensuring full accessibility of polling stations for persons with disabilities. On paragraph A, the state party informed the committee that the electoral code ensures transparency and accountability throughout the electoral process, including campaign financing. It mandates full disclosure of campaign contributions and expenditures to the Audit and Oversight Service, which conducts reviews and reports findings to the Central Electoral Commission. This commission must publish these reports immediately and address any violations. If campaign goods or services are not reported, or if spending exceeds legal limits, administrative penalties are imposed. In certain cases, a candidate's or party's registration may be invalidated by court decision. If penalties are not paid or appealed, the Central Electoral Commission may recover the funds through legal action. On paragraph B, the state party noted the rules on elections in the Constitution and Electoral Code. It informed the committee that the right to be elected may be restricted on two grounds. A, persons lacking active legal capacity as declared by a civil court. And B, persons sentenced by a criminal judgment serving a punishment. As regards persons lacking active legal capacity, the state party maintained that the limitation of a person's legal capacity inevitably leads to a possible restriction of the rights and freedoms of this person in certain legal relations. The state party further informed that not all persons with intellectual or psychosocial disabilities are recognized as incapacitated, and that therefore, in law and in practice, persons with disabilities, including intellectual or psychosocial disabilities, have the right to vote. As regards the non-nomination of persons as candidate at the time of imprisonment, the state party informed that this is not a deprivation of the electoral right, but a temporary suspension. When the sentence is completed and the individual is released, the individual will enjoy the right to be elected. As such, the constitutionally fixed restrictions on the right to be elected are justified, meeting the interests of society and complying with the principle of proportionality. On paragraph C, the state party reports that under Article 17 of the Electoral Code, local authorities must ensure that polling stations are accessible to voters with limited mobility or visual impairments. The Central Electoral Commission may set additional accessibility standards. In September 24, a legislative package was submitted to the National Assembly, proposing reforms to enhance electoral transparency, fairness, and efficiency. Some of the key reforms include stronger financial oversight of political parties, improved voting access for individuals with mobility impairments, including the option to vote at a more accessible polling station, and stricter standards for the selection of polling stations, ensuring entry and mobility for persons with disabilities, as well as measures to facilitate the exercise of voting rights for individuals with visual impairments. The human rights defender noted that there are several systemic barriers to the political and public participation of persons with disabilities. These barriers primarily concern inaccessible election precincts and environmental obstacles, such as lack of ramps and absence of nearby transport and proper road crossings. Inaccessible digital platforms, including the website used for public consultations on draft legislation, legal restrictions under Article 48(4) of the Constitution, which deny voting rights to individuals declared by a court to be incapacitated, and limited accommodation for persons with mobility impairments during elections. On the basis of this information received, the committee's evaluation for paragraph 42 is B. The committee welcomes the legislative package submitted to the National Assembly, proposing amendments to the Electoral Code, in particular regarding new tools for financial oversight, as well as measures to increase the accessibility of polling stations for persons with disabilities. It is, however, concerned about information indicating that institutional barriers to political participation of persons with disabilities remain. It regrets the legal restrictions under Article 48(4) of the Constitution, denying persons recognized by a court as incapacitated the right to elect and to be elected, and the right to participate in referendums. The committee reiterates its recommendations and requests further information on A, whether any administrative proceedings were initiated by the Central Electoral Commission during the reporting period, and if so, whether any violations were found to be substantiated. B, any further steps taken to revise eligibility requirements to ensure that there are no undue limitations on the right to stand for presidential and legislative elections. And C, on the progress of the adoption of the legislative package and on the new tools to be implemented. So these are the proposed gradings, 3 times a B for Armenia, and I return the floor back to you, Chair.
Thank you very much, Madam Donders, for your very good presentation. Then I will, is there any members who wish to speak? Yes, Mr. Helfer, please.
Thank you, Chair, and I sincerely thank Ms. Donders for her very thoughtful presentation and for the report on which it is based. I will simply say that the follow-up procedure is really vital to the committee's work. It shows, as Ms. Donders emphasized, the need to focus not only on the formal legal framework, the law on the books, as it were, but also its application in practice, how it is applied, with what degree of effectiveness, and with what impediments. And I think a theme that emerged from the report and the grading here is that the state party has made substantial progress with respect to improving the legal framework, but they still have some work to do with regard to implementation and effectiveness. And I think that is a theme we often see in the follow-up on concluding observations, and it is something that I urge all stakeholders, not only state parties, but civil society and national human rights institutions to focus on as they work toward full implementation of the covenant. Thank you.
Thank you very much, Mr. Halfer. I give the floor to Mr. Gezu.
I thank you, Chair, and first of all, I'd like to congratulate Ms. Donders for providing this report and a very thoughtful and well-balanced report. And as my colleague, Mr. Helfer, stated, I think all the grades reflect a balance on that the state party has taken steps towards implementation of the recommendations, but further actions need to be taken, and that's exactly what is done. And again, I mean, this is a very important thing. We've seen the alternative reports, and based on those reports, we that the grading was, I believe, is correct. And therefore, I also agree with the grading here. It's a well-balanced and very thoughtful grading. And again, congratulations to Ms. Thunders. Thank you.
Thank you very much, Mr. Geju, for your good words. And Madam Basim, you have the floor.
Thank you, Mr. Chairperson, and good morning to you. Good morning, colleagues, and all who are following us on the webcam. I would like to express at the outset my appreciation and sincere thanks to Madame Donders for the excellent effort she has exerted in preparation of this report on follow-up to the concluding observations of the review of both Armenia and Germany. As for Armenia, I fully agree with the content of the report for the analysis, the objective analysis of the information provided therein by different stakeholders on the three recommendations of the Committee on Human Rights to the State Party upon its review. And I agree with the grading that she has presented here, recognizing the efforts made by the State Party to implement those recommendations and encouraging them to see the points of weaknesses and to try to overcome them. So their grading in the next review will be improved. And I again remind the public and the state parties that the role of the committee is to accompany the state parties to the covenant to the best possible implementation of their obligations upon their ratification of the covenant and its entry into force for their own state. Thank you very much, and thank you again, Madame Donders, for the excellent work you have achieved.
Thank you very much, Madam Basim. Now I give the floor to Mr. Ndiaye.
Bonjour.
Good morning. Good morning, dear colleagues, and welcome to the participants as well. Those who are here in the rooms, such as the Centre, and those online. And thank you so much, Yvonne, for this fabulous work. Excellent presentation as well. And your devotion and ardor to your work. I think we need to encourage states, support them. And I think the first thing is you need to acknowledge the progress that they've made. Say, basically, excellent, you've made progress, but carry on, keep up the good work. The other approach is to acknowledge their failings and tell them constantly to their face that this is not working and these are your failings. On the one hand, I agree entirely what we've got on violence against women, participation in public life, but peaceful assembly, excessive use of force, I don't personally agree with that. I think it should be a C rather than a B. This goes back to 2008. We're now in 2015. We're still at the inquiry stage, are we not? So I don't think you can do that. 14 years of investigations and inquiry without any judgment, and recognizing this is actually helping them, such as the ombudsperson who've said this isn't working, or the prosecutor who took that up in 2024. I mean, 2024, for things that go back to 2008, that's hardly speedy, but it needs to be an encouragement. Excellent what you've done so far, but you need to do more, which is why I would have suggested C for excessive use of force. There seems to be a bit of backsliding there. I mean, investigations that take more than 10 years. I'm not good at maths, but let's say 2008 to 2025, that's 13 years, is it not? And no progress there, no ruling, no judgment. And I think that needs to be acknowledged and say quite clearly that it's a C rather than a B. That's my proposal.
Thank you, Mr. Ndiaye, for your proposal. Now I give the floor to Mr. Fernandez Lieza. No, Mr. Carozzo. I'm sorry. Carozzo. Yes, Carozzo.
Te va a ir mal, Carlos.
We're still getting mixed up, you and me, Carlos. Thank you. Thank you, Chair. I just wanted to echo what's been said just now on the magnificent work done by Yvonne, who absolutely masters the topic, and indeed the whole proceedings and processes involved. Now, although there was an invitation to provide information on compliance, the National Human Rights Institution of Germany apparently didn't do that, which is very regrettable. And again, I'd like to thank Madame Donders for this explanation that she gave us, and indeed you kicked off with that explanation on the whole process involved and the role of the special rapporteur in this. So we have before us for approval this text. Now, we have two assessments for Germany. And Armenia. Now, the question is whether the rapporteur, as part of this general presentation she gave us, how do you select the states that have to be rated? Is there some sort of geographical representation involved here, or geographical spread when you're identifying states? So, for instance, you're not just dealing with one continent or one region, which is the case here. So I'd appreciate some answer from Yvonne and indeed the Secretariat as whether anybody can enlarge on that. Thank you.
Thank you very much. If there are no other members to intervene, I'll give the floor to Madame Donders.
Thank you very much, Chair, and thank you, colleagues, for your very kind words and also your support, but also your critical remarks. Let me start perhaps by the remark made by Mr. Ndiaye about the grading, in particular, of paragraph 40 of the Armenian report. I completely follow what you're saying. And I also think it might indeed be a good idea to give some extra emphasis to this particular issue, which is very, very serious and very concerning. That indeed some of the investigations are still pending after so many years, but also that there seems to be still, as the National Human Rights Institute, the Human Rights Defender of Armenia, indicated, there's still a lot of violence and use of force that is undue. So now I would like to hear also then from colleagues, because we could change this into a C as far as I'm concerned. But since several colleagues agreed with B, I do need to hear a bit, or at least see nodding or something, to see whether indeed the rest of the committee members can agree to that. So my concrete proposal here now is to change the grading for paragraph 40 of Armenia into a C. It also highlights a bit the others where indeed much more progress seems to have been made than in this one. So my proposal would be to change the grading into C. And then I will come back to Mr. Carrasco's question.
Okay, thank you very much. So Madame Donders have changed her the original proposal. So I'll give the floor to Mr. Igeju.
Yes. Thank you. I mean, this is a borderline probably issue, but still, what is, there are serious problems, and then the state party, but the state party has also responded that, and here there are actions that have been taken towards the implementation of the investigations have continued. The state party has issued certain reforms. So there are actions. When we say C is usually when the state party hasn't taken, that the information provided by the state party shows that it is that the actions taken are not relevant. There are relevant actions that have been taken, and or does not implement the recommended. There is, to a certain extent, steps taken towards that, as we can see from the information provided by the state party, but there are serious situations. I think it's on the, so to encourage the state party to further take actions, I think for me a B is more appropriate than a C, because it implies that the state, if we give a C, it implies that the state party did not implement the recommendations. It's a borderline case, but in my view, it's on the measures to be taken when in the committee's assessment. That if there is a need to strengthen that, but in my view, it's B is also an appropriate grading, but I leave it to the rapporteur, of course, to decide on the and on the grading, because I don't also feel strongly whether it goes to, but yeah, that's the thing I have to say. Thank you.
Okay, thank you very much, Mr. Igeju. So Igeju want to keep the grade B rather than C. For the clarification, the grade C, even if you know that the response has been received, but action taken or information provided by the state party is not relevant or does not implement the recommendation. So, okay, Madame Donders.
Thank you. I agree with what Mr. Yegesu just put forward. And I think one solution could be, because what we're mostly talking about, if you look at the different recommendations, we now put them together. We don't always do that, but we have in many of our recommendations an A and B and a C, as I just outlined. And I think what we could do here, because the issue that Mr. Ndiaye raised was mostly about recommendation paragraph 40A, because there's been this, here we say, strengthen efforts to ensure that all law enforcement officers found responsible, etc., are held accountable and appropriately sanctioned. And we could say that that just has not happened yet. For the others, I agree with Mr. Yegesu. Actually, there is quite some progress made. Sometimes it's also a bit more long-term issues that are not just one-off events, but more things to be developed over time. So then I do another proposal in light of having consensus in the room that we give a C only for paragraph 40A, but that we remain the B for paragraphs B, C, D, and E. Because there we, I think, can recognize that the country, the state party, made actually progress and did not do, well, seriously not enough to implement our recommendation fully. So this would be my new proposal, Mr. Chair. Thank you.
Thank you very much, Madam Donders. I see many members nodding, so that must be a very good proposal, and members accept the proposal. Any members who disagree with the decision made by Madam Donders, suggestion made by Madam Donders? Okay, I think it is agreed. Then to the question proposed by Mr. Carazzo, please, I go back to you.
Thank you. The question, if I understood correctly, is how do we get to these two countries? Why not others? Do we select? Do we? How do we determine which countries we have for follow-up? Well, first of all, of course, we depend a lot on the submission of reports, follow-up reports by the states parties. As you know, every time we adopt our concluding observations, we ask the state party to come back to us with a follow-up after 3 years on the 3 selected issues. Some states do that, some states don't. Some states do it on time and some do it a bit later. So there is a grouping, and to be honest, at this moment, there's quite a lot of follow-up reports pending, where we're waiting for states parties to come back to us. And then, of course, it depends also on whether then we ask also other stakeholders to submit information. And I fully agree with Mr. Carazzo that it's very unfortunate that this time we only had one very good report information by the human rights defender of Armenia, but nothing from Germany and also not from other stakeholders in both countries. So that also requires a bit of time when they respond to us, or we give them some time to respond to us. So then we basically deal with them when they are there. We do not, as far as I know, select on the basis of regional distribution, or we try to deal with as many follow-up reports as we can within the time and budget constraints that are also a reality. Let's face it, the budget constraints affect also the follow-up procedure. There's less time, less preparation possibilities. But overall, we take those that come in, and as soon as they're ready, we try to also do our assessment. And I think the Secretariat and also the committee is doing its utmost to deal with them as soon as we can, because it's important, as I said, and as also was just referred to by Mr. Helfer, it's important that we, during that 8-year period, remain in contact and remain accompanying, as Madame Wassim was saying, the state party in implementing the covenant. Thank you.
Thank you very much for providing the answers. Mr. Carazzo.
Thank you for the answer. A very clear and precise answer. Thank you. You talked about states that don't provide any report, that are really lagging behind and very slow in providing their follow-up reports. just a consideration for the special rapporteur, perhaps, for future ones. Could this be something that could be included, some sort of follow-up report or for a country that doesn't comply? Something could be put in. I don't know. Maybe just a paragraph. The second question is, are there states with sort of queuing up, so to speak, to be included in an annual report in upcoming years? Thank you.
Okay, Madam Donders.
Thank you very much, and thank you, Mr. Carazo, for these suggestions. I will take them on board. I think we regularly urge states to respond. There's also information on these dates and deadlines, as far as I know, is publicly available. I personally am not so much into naming and shaming in this regard, because there may be many reasons for states parties to not be able to submit. But of course, we can keep in touch with them. I agree with you that we should urge them, as well as I said, other stakeholders, to participate in this procedure. And whether we can make a note, I think there's always something in our annual report on the follow-up. So let us discuss this when we discuss how we draft that that annual report.
Thank you so much. Is there any other members? Yes, Madam Bassim, you have the floor.
As far as the last, thank you, Mr. Chairperson. As far as the last intervention of Madame Donders on the possibility of making a report that would collect all the names, the proposal by Mr. Carazo, I fully support the point of view of Madame Donders. Our work is not to name and shame. We have to continue very in quite a persisting in drawing the attention and asking the state parties to implement the recommendations, and also to encourage the other stakeholders to do the same, to continue monitoring closely the progress achieved or the regression that could happen with the state parties. But the issue is not to name and shame, it's to accompany them, to encourage them, in the contrary, to abide by their commitments to the covenant. Thank you, Mr. Chairperson.
Thank you very much, Madam Bassim. So if there's no other member who wish to say, I'd like to conclude. Maybe Madam Donders, you want to take a floor again?
Yes.
Oh, that's right. I'll conclude. I'm sorry. Conclude the Armenia. Then I will go back to the Madam Donders for the Germany.
Thank you very much. I think it's only fair that we do justice to both states, even though we had, of course, some more extensive discussion on more general issues after the grading of Armenia. And let me also make clear to the outside world, it's not that many states parties do not perform well. Actually, most of them do submit follow-up reports on time and with serious information in it. And that goes certainly also for the country I will now discuss, namely Germany. So the three recommendations selected for follow-up were paragraph 21 on intersex persons, paragraph 31 on institutional care, and paragraph 43 on the right to privacy. Under paragraph 21, the state party was recommended to take all steps necessary to ensure that all acts relating to the assignment of a sex to intersex children performed without their free and informed consent are specifically prohibited, except in cases where such interventions are absolutely necessary for medical reasons and the best interest of the child have been duly taken into account. This should include the consideration of amendments to the law on the protection of children with variations in sex development of 2021. The state party should also ensure that all victims have access to remedies including through a revision of the application of statutes of limitation for violations in childhood, taking steps to ensure that all victims have access to their health records, and considering the establishment of a dedicated compensation fund. The State Party informed the committee that under the Act on the Protection of Children with Variations in Sexual Development, a new section 1631E was inserted in the Civil Code that prohibits to align children diagnosed with sexual development variance to an assigned sex if they are unable to consent. Parents or court-appointed curators may not consent on behalf of the child. Also, surgical intervention on a child's internal or external genitalia is only permitted with parental consent if the procedure cannot wait until the child is able to consent, and only following ratification by the family court. The new provisions are to be reviewed and evaluated within 5 years. Individuals affected by violations of the legislation are entitled to extensive compensation under civil law and state compensation in certain circumstances. In some cases, criminal charges may also be brought. The State Party further informed the committee about the working of specific sections of the Civil Code on disclosure and information, on keeping medical records until the person reaches the age of 48, and on the right of inspection upon request of complete medical records. The State Party further reported that a review is underway to evaluate how to further improve safeguards, such as by defining in more detail when sex assignment intervention is prohibited and by facilitating access to medical records. Courts, relevant associations, researchers, and civil society are providing input. The State Party also informed that unlawful genital altering surgery can lead to criminal prosecution for bodily harm and female genital mutilation, and victims may be entitled to receive social compensation. Victims are also guaranteed sufficient time to bring claims. On the basis of the information received, the committee's evaluation for paragraph 21 is B. The committee welcomes the information that a review is underway to evaluate how to further improve safeguards for intersex children, and that a review of the new provisions under the Act on the Protection of Children with Variance in Sexual Development will take place within 5 years from its adoption. It regrets, however, the lack of concrete information provided on the steps taken to ensure compliance with and the adequate implementation of the Act, and guarantee the provision of remedies in practice. It therefore reiterates its recommendations and requests further information on the progress of the legislative review and statistical data on the number of complaints received regarding violations of the legislation, or on any criminal charges that have been brought, and on the compensation provided to victims. On paragraph 31, institutional care, the committee recommended that the State Party should A. Continue and step up efforts to monitor, prevent, and eradicate the use of physical and chemical restraints in institutional care settings. B. Intensify efforts to monitor, prevent, and eradicate all forms of abuse against older persons and those with psychosocial disabilities in residential care facilities. C. Consider further harmonization of the legal standards in the different länder on the involuntary hospitalization and forced committal of those with psychosocial disabilities. D. Remove any exception in the law to the ban on the forced sterilization of adults with disabilities and ensure that such standards are effectively implemented. E. Consider increasing the availability of specific complaints mechanisms to receive, investigate, and facilitate the prosecution and punishment of those responsible for all forms of abuse in institutional care settings. And F. Take targeted measures to protect older persons from coronavirus disease and other major public health emergencies and restore full regulatory oversight. Under A and B, the State Party informed the committee that measures are in place to advise care homes and services on and monitor their compliance with legal and medical standards, such as annual quality inspections and unannounced inspections. Findings are published and may lead to corrective measures or sanctions. Inspectors examine whether measures involving deprivation of liberty, such as mechanical restraint and sedatives, are being avoided where possible, and when there is no alternative, they are being employed correctly, with consent and authorized by courts in accordance with the Civil Code. The competent supervisory authority responds to complaints regarding the use of measures involving deprivation of liberty. Where mistreatment or sexual abuse is suspected, it works with criminal investigation and prosecution authorities. The state party also informed the committee that facilities receive guidance on reducing the use of restraints and that staff is trained on preventing violence. Since 2019, long-term residential care facilities are required to record quality data biannually based on 10 quality indicators. A national process is currently underway to improve protection against violence, aimed at reducing the use of measures involving deprivation of liberty and meeting the needs of persons with psychosocial disabilities. On C, the state party informed the committee that pursuant to the mental health acts of the lender, a person may be placed in a clinic against his or her will if there is an acute and considerable risk of self-harm or harm to others. Following decisions of the Federal Constitutional Court, the mental health acts of the individual lender are becoming increasingly uniform in the areas of physical restraint and compulsory medication. The principles of necessity and proportionality are taken into account, and the state party reported in detail on various legal standards that apply in the mental health acts of all lenders. Under D, the state party reported that a new section 1830 was included in the Civil Code, according to which sterilization is permissible only if the person incapable of consenting agrees to it. For persons who are incapable of forming or expressing their natural will, sterilization is now prohibited. The Civil Code further requires, in order to protect the will and wishes of persons incapable of consenting, that the supporting legal representative provides the person concerned with comprehensive information and advice and establish their actual will in the interest of a supported decision-making process. The state party also informed the committee that the legislator has decided against a complete statutory ban on proxy consent as part of the reform of guardianship law. Sterilization is a method of contraception that is frequently used by persons who do not have supporting legal representation. By prohibiting this option, persons incapable of consenting would be enabled to use it even if it corresponded to their self-informed wishes. The state party considers that an absolute ban would deny such persons the right to choose a particular contraceptive method, which would be incompatible with their right to self-determination. On paragraph E, the state party reported that persons requiring care and their relatives may at any time contact the Long-Term Care Insurance Fund or the competent care home inspectorate. These bodies may then commission unannounced inspections, and if there are sufficient factual indications of a criminal offense, the public prosecutor's office is obliged to investigate. The state party further informed the committee that the provisions governing care homes at the land level have been or are currently being amended. In some lender, centralized and decentralized complaints offices have already been set up and more extensive complaints mechanisms are being discussed. On F, the state party informed the committee on various protective measures it had taken during the COVID-19 pandemic for the general population and in particular for older persons. It also informed the committee that a national lessons learned process is underway to document experiences of the pandemic and enhance the resilience of the care system to future crises. On the basis of information received, the committee's evaluation for paragraph 31 is B for sections A, B, C, and E, a C for section D, and an A for section F. First, on paragraphs A, B, C, and E, which we graded with B. While welcoming the 2022 resolution on protection from violence for people in need of care, which initiated efforts to develop practical safeguards, the committee regrets the absence of specific data on inspections of care facilities, the outcomes thereof, and the sanctions imposed in relation to the use of physical and chemical restraints. It requests further details on the process referred to by the state party aimed at improving protection against violence in long-term residential care facilities, reducing the use of measures involving deprivation of liberty, and meeting the needs of persons with psychosocial disabilities. The committee notes with satisfaction that the mental health acts of the lender are becoming increasingly uniform in the areas of physical restraint and compulsory medication, and requests further information in this regard. While noting the information provided on the standards applied in the mental health acts of all lender, the committee regrets the lack of information on further steps taken to harmonize the legal standards in the different lender on the involuntary hospitalization and forced committal of those with psychosocial disabilities. And the committee reiterates its recommendation in this regard. The committee welcomes the efforts being made to amend the provisions governing care homes at the land level and the establishment of complaints offices in several lender, and it appreciates that more extensive complaint mechanisms are being discussed. The committee requests further information in this regard and specific data on the number of complaints of abuse received, the investigations that have been conducted and the results thereof, including the sanctions applied. On issue D, which I propose to grade with C. While welcoming the replacement of former section 1905 of the Civil Code with new section 1830 through the Act to Reform the Law on Guardianship, the committee regrets that the legislation still provides for circumstances under which the forced sterilization of adults with disabilities remains permissible. It reiterates its recommendation. On F, which we grade with A, the committee welcomes the steps taken by the state party to provide older persons, to protect older persons from COVID-19 and to ensure long-term preparedness, including by setting up a national reserve for health protection. It requests additional information on the progress of the national lessons learned process referred to by the state party. On paragraph 43, the right to privacy, the committee recommended that the state party should ensure that all types of surveillance activities and interference with privacy are in full conformity with the covenant. Such activities should comply with the principles of legality, proportionality, and necessity, and be subject to judicial authorization. The state party should also ensure that surveillance is subject to effective independent oversight mechanisms, namely judicial mechanisms, and ensure access to effective remedies in cases of abuse. The state party informed the committee that German law ensures that all types of surveillance activities and interference with privacy are in full conformity with the covenant, and noted that the covenant does not state that all types of surveillance activities should require judicial authorization. The state party also reported on the working of the Federal Intelligence Service Act and the Federal Intelligence Service. The Federal Intelligence Service Act has repeatedly been reformed to ensure that its actions have a secure and precise legal basis and comply with national and international human rights obligations. Legislative amendments were also made in response to decisions of the Federal Constitutional Court. The state party further informed the committee that the Independent Control Council, established in 2022, provides independent legal oversight of federal intelligence services, and it explained in more detail the working of several control mechanisms. The state party further reported that criminal investigations require legal authorization and must adhere to the principle of proportionality. Surveillance by technical means, such as remote searches or monitoring of telecommunications, is permitted only under strict conditions with judicial approval, except in urgent cases when an order by the public prosecutor must be judicially confirmed within 3 days. Extensions beyond 6 months for remote searches require higher court approval. Both types of surveillance are subject to rules on data protection relating to private life. Judicial decisions on surveillance are subject to appeal, and illegally obtained evidence may be deemed inadmissible. On the basis of the information received, the committee's evaluation for paragraph 43 is B. The committee welcomes the state parties' efforts to ensure that all types of surveillance activities and interference with privacy are in full conformity with the Covenant. In particular, it notes with satisfaction the reforms of the Federal Intelligence Service Act and the legislative amendments made in response to decisions of the Federal Constitutional Court, including the establishment of an independent control council in 2022 to provide independent legal oversight. The committee regrets, however, the lack of concrete information on the practical implementation of the Federal Intelligence Service Act. It requests additional details on the reforms of the Federal Intelligence Service Act that have taken place since 2021 and concrete information on the work of the Independent Control Council. Furthermore, it requests data on the complaints received regarding any abuse of surveillance powers, the investigations carried out, and the results thereof, and effective remedies provided. These are the proposed gradings for Germany, and I return the floor back to you, Chair.
Thank you very much, Madam Donders, for your presentation and proposals. And now I will open the floor to the members. Madam Bassim, please.
Thank you, Mr. Chairperson, and once again, thank you, Madam Donders, for this report on follow-up to the concluding observation for the review of Germany in November 2021. I welcome the fact that the state party has been on time in presenting its information on the 3 recommendations that were chosen by the committee. I agree with the grading of paragraphs 21 and 31 in all its 31 all subparagraphs, but I would rather propose a grading of C for the last paragraph 43 on the right to privacy, because I find that still no action has been taken on the legal amendments, following the legal amendments that were done as far as the Intelligence Service Act and its reforms. We are still lacking information about the implementation, as I just said, the details on the reforms, but more than anything, the data or an aggregated data on the complaints received as far as abuse of surveillance and investigation and effective remedies provided to the victims. Why I make it C for Germany? Because it's an advanced state. They have the means to implement. It's a democratic state, and the right of privacy is an integral part of democratic practices. And they have the means to present data, to present information on what the committee has requested them. So I would propose to grade the state party C on this particular paragraph. Of course, the final decision is in the hands of the rapporteur, resulting from any discussions that would take place on this issue. Thank you very much.
Thank you very much, Madam Basim, for your suggestion. Is there any other members who wish to intervene or have opinions? Mr. Helfer, please.
So I think we need to bear in mind. So first, let me thank you, Chair, and thank Ms. Donders again for another excellent report. I have given some consideration to this issue and have again go back to the point I raised earlier regarding implementation and what needs to be done. One also needs to review that and assess it in light of two other factors. The first would be what precisely is mentioned in the recommendations in the prior concluding observations with respect to the state party. We have to grade the state party in light of what we requested, in this case, which was primarily legislative modification. And in addition, we also have to apply consistent principles with regard to the grading across all states parties. Taking both of those factors into account and having looked at the information provided by the state party, I have agreed that with my colleague Ms. Basim, that reasonable minds can differ on this, but I think that on balance, the grading of B is appropriate in light, in this situation and in light of the factors that I've just mentioned. So I would retain the recommendation as proposed by Ms. Donders. Thank you.
Thank you very much, Mr. Helfer. Is there any other opinions? Yes, Mr. Igeju, you have the floor.
Probably following what Mr. Helfer said earlier on, I also thought that the evaluation also should be based on the recommendations or the concluding observations we made on paragraph 43, and one of the issues was the surveillance activities were in line with the covenant, and also more importantly that this kind of surveillance is subject to an effective oversight mechanism, and I think the state party has also taken steps in this regard. So acknowledging the steps that have been done, I understand Ms. Basim's, but that is not the only issue. So the state party, similar to the previous, when we talked with Armenia, has made several steps to ensure that, and recognizing that we ask for further information, more concrete information on the practical implementation of what is being done. So I think it's quite a balance here, and I think that the state party has taken positive steps, but still that there are other issues that remains to be taken, and I think it's fair to give a B in this instance also. Thank you.
Thank you very much, Mr. Igeju. Is there any other members who like to express your views? Maybe Madame Donders, can you? Yes, you have the floor.
Thank you, Chair, and thanks, colleagues, for thinking with me and thinking with the committee on proper grading for all of these actions and recommendations by states parties. Although I see indeed Ms. Basim's remarks, and I agree that many things probably still indeed are not fully in line with the covenant, I would, however, still propose the B grading, because what we indeed ask for in the recommendation is mostly reforms in the legal as well as reforms in practice, but not so much concrete information and data, which is usually indeed not in our COPs that we ask for that kind of information. We do that in our dialogues and in our list of issues. But if we then see how the recommendation has been implemented, there has been quite a lot of concrete legislative reforms have taken place in the country, particularly on the issue of privacy and monitoring. And also there is the establishment of the Independent Control Council, which oversights, which monitors intelligence services. So actually quite a lot of activities have been undertaken by the state party. And the fact that we indeed now in our follow-up report ask for additional information and data, which I'm sure indeed this country might be able to provide, is to monitor the practice as of now, because the legislative reforms now have to become practice, and let's see how effective these reforms are. And therefore we ask for additional information, which I think the state party indeed is probably very willing to provide and at least able to provide in our next review cycle and their next periodic report. So with all permission, I would like to stay with the grading of the B for this paragraph. Thank you very much.
Thank you very much, Madame Donders. Sometimes, it's very difficult to make a decision between the grades B and C and A and B. Sometimes I think we better have B minus or C plus in our grading, but that's how it goes. And there's a suggestion by the Madame Donders, and I think there are general feeling of agreeing to the Madame Donders' suggestion. So if the Madame Basim agrees, then we can make a decision. Okay. Do you have to take a floor?
And I just expressed my point of view in view of the importance of the state party and my thinking that we can understand sometimes the non-full compliance of some states, smaller or with less capabilities and capacities. We ask from the more advanced, even more rigorous implementation of their obligations, but I don't feel strongly about it. Thank you.
Thank you very much for your cooperation. Then I think the proposals by the Madame Donders are accepted by the committee. So thank you very much. And maybe finally I'll go back to the Madame Donders, your final words.
Thank you very much, Chair. And I would like to thank all the members of the committee, and of course also those attending this meeting in person and online for their attention. I also should sincerely thank the Secretariat for their very, very hard work in preparing this report with me, as well as, of course, the conference services. But also, let me take this opportunity to publicly also thank our interpreters, who always make it possible for all of us to speak and follow in a preferred language. And with that, I pass the floor back to you, Chair, and thank you.
Thank you very much, Madame Donders. So to conclude, once again, I wish to express my gratitude to the Special Rapporteur on concluding observations, Madame Donders, for your insightful presentation. and to all other members and staffs for their contributions and spirit of cooperation and unwavering commitment. So meeting is adjourned.